second chapter is arbitration agreement. So in the first chapter, definitions are of much importance for those who practice or those who intend to practice or those who intend to get into this field. Definitions are of much importance because they give you an idea as to how to go about a certain thing that's provided under the act. That is the first stepping stone of how you approach a section or an act, right? There are many definitions that are important, but because there's constraint of time, I'd not be getting into it. But just to give you the general idea, you should be aware of the definition in a proper fashion. That is section 2. Definition is section 2. In the first part, there's another important section, that is section 4. That is waiver of right to object. But I'll get into that when I'm dealing with section 16, that is the power of the arbitral tribunal to deal with its own jurisdiction. But now chapter 2. Chapter 2 is arbitration agreement, and it has 3 sections in it: section 7, section 8, and section 9. So section 7 provides for arbitration agreement. Now, what is arbitration agreement? We have already what is arbitration? We have dealt with it, but is what is an arbitration agreement? For parties to get into for parties to refer to arbitration, there has to be a written arbitration agreement. It could be part of the contract that that parties have entered into, or it could be in the form of a separate contract as well. It Why it is there, one may ask. It's there to show it's there to document the intention of the parties to resolve their disputes, if at all, through arbitration agreement. So arbitration agreement needs to be very clear. It has certain important things that need to be documented in that or written down. That is, that parties, first of all, that parties intend to resolve their disputes through arbitration. Second, the place of arbitration. Third, the language of arbitration. Fourth, whether it will be administered by one arbitrator, two arbitrator, three arbitrators, four arbitrators, five arbitrators. But the general practice is either one arbitrator or three arbitrators, right? And there's one more thing. There's procedure, which we usually do not see in practice until unless the arbitration is agreement between two parties that are dealing with a complex commercial issue or a complex commercial transaction. Otherwise, they don't usually prescribe for procedure, but they are well within their right to write down how the arbitral procedure will be. I'll tell you what I mean by procedure when we again come to section 19. Now, section 8. Section 8 is power of the courts to refer the parties to arbitration. You may think, why do we need this section, right? When the parties have already agreed for an arbitral for resolution of disputes through arbitration, why would we need this section? But this happens at times when, even though there is an arbitration agreement, one party approaches the court, the normal courts that we see, the district court or the high court or the supreme court, whatever the case may be. They approach the court for resolution of their disputes. At this time, this section comes to play, and the other side could make a representation before the party in reply to application under section 8 that there's an arbitration agreement. Please refer the both of us to arbitration. There's no need for either of us to come before you as in court, right? Now comes section 9. Section 9 is interim measures by the courts. So I'll get to interim measures when I'm telling you about section 17, that is interim measures by the arbitral tribunal. But to give you an idea, a party can approach the courts to for interim measures before an arbitral tribunal is constituted and after the award is made. There could be multiple reasons for it, but as I said, I'll deal with this when we are dealing with section 17, that is interim measures by arbitral tribunal. In the meanwhile, you guys could write it down and think about it as to why we would approach court for interim measures rather than an arbitral tribunal, or why would we need this section at all. Now there comes chapter 3, that is titled Composition of the Arbitral Tribunal. It is from section 10 to section 15. And first of all, I'll talk about section 10. Section 10 provides for the number of arbitrators. So section 10 says that the number of arbitrators ought to be an odd number, either 1, 3, 5, 7, 9, whatever. It has to be an odd number. And in case there's a failure of appointment as such of 1, 3, or 5, or 7, or 9 arbitrators, there will be one arbitrator. Right? This is what section 10 says. But there's an interesting case of 2002. By you guys could write it down if you'd like. I'll give you the name and the citation. That is Narayan Prasad Lohia versus Nikunj Kumar Lohia, AIR 2002, Supreme Court 1139. This is a very interesting case. In this case, there were two arbitrators, not one, not three. This is directly in teeth of what is said under section 10. This case reached Supreme Court, and the one of the parties said before the court that this award is illegal. The award was made. They participated. Both the parties participated in the arbitral proceedings. Everything was there. One of the parties objected to the enforcement of the award, and it reached Supreme Court. And one of the parties said that since there had to be either one arbitrator or three arbitrators according to section 10, this award is illegal. The Supreme Court disagreed. The Supreme Court said that this award is valid. Just a moment. Yeah, the Supreme Court said that this award is valid even though there are two arbitrators. Why? Because both the parties participated, both the parties agreed to the procedure, both the parties presented their case, and it wasn't as if the two arbitrators gave divergent opinions. There was a unanimous award, so it was upheld. The Supreme Court said that it did not affect the fundamental policy of India. That is part of section 34. I'll get to it when we the fundamental policy of India, why it is important, that I will explain when we get to section 34. So where were we? Yeah, section 10. So that is section 10. Section 11. So section 11 is of much importance when it comes to practice of practical aspects of arbitration. Section 11 provides for appointment of arbitrators by the courts. So what happens is that, say for example, A and B got into a contract. They have an arbitration agreement. One party invokes arbitration, sends a notice invoking arbitration, saying ki, I have these problems with you, and I am entitled to this much amount of money. Please nominate an arbitrator, or I have nominated mine. If it's a 3-member tribunal, then you nominate yours, the other party nominates theirs, and the third one is appointed by the two arbitrators. If it's an ad hoc, then both the parties agree on one arbitrator. So if that notice invoking arbitration is not replied to within 30 days, the party who has sent the notice invoking arbitration can approach court under section 11, saying that I have followed the procedure prescribed under the act, but the other party has not either given consent to my nomination or have not appointed their arbitrator, or we couldn't agree on a single arbitrator. Please appoint an arbitrator so that resolution of disputes could go on. This is of much significance because this happens almost on a daily basis in our courts. If you guys have the opportunity to go to any court, you will see that at least 10 section 11 applications are there, listed on a daily basis, right? Because it so happens that either parties don't reply, or they don't agree, or they don't give consent to uh, a single arbitrator. Then the other sections in this chapter deal with the biasness of the arbitrator or the termination of their mandate, but that's let's not get into that today. I'm already seeing the time is 5:30, so I'll only speak to the important aspects as what is actually followed. Now comes chapter 4, of much importance yet again. Chapter 4 is jurisdiction of the power of the arbitral tribunal to rule on its own jurisdiction. So let's take an example. One of you and I have entered into a contract. We have an arbitration agreement. We have appointed an arbitrator, or the court has appointed an arbitrator for us. Now you have a problem with the arbitrator, saying that the disputes that have been submitted to you cannot be adjudicated upon by you, or cannot be are beyond the contract, right? What do you do then? So you have an arbitration agreement which says ki any or all of the disputes arising out of this contract shall be referred to arbitration, shall be resolved by a mechanism called arbitration. In that case, if an arbitration agreement is worded this way, that any or all of the dispute arising out of a contract, then the arbitrator has the jurisdiction to preside over any or all of the disputes. But say, for example, there is an arbitration which says only a certain type of disputes could be referred to arbitration, and it precludes certain other type of disputes from arbitration, and still the precluded disputes have been referred to the arbitrator. One could make an application under section 16 before the arbitral tribunal and say that you are not authorized, or you do not have jurisdiction to preside upon these disputes. And the tribunal, by examining that application, can itself make a ruling as to whether it can resolve those disputes or not. Coming to the practical aspect of it, an order passed by an arbitral tribunal is generally considered a part award, and that is challenged under section 34. If you guys are aware of the scheme of uh, uh, how an arbitral award is challenged, never mind, I'll get to it again. I'll get to it. So what happens is, even though it is ideal that the challenge to the jurisdiction of an arbitrator is decided before he actually makes a determination on the disputes, what happens in the practical sense is that he says that the arbitral tribunal says that I'll make an award on this section 16 application along with the award. Why? Because it is considered as a part award, and you can only go against the order of an arbitral tribunal under section 16, under section 34, for setting aside of the award. You cannot have any recourse apart from, you do not have any recourse apart from section 34, right? And that happens only after the proceedings are completed. The arbitral proceedings are completed, either by way of termination or by making of an award. This particular uh, concept is called competence. And I'd like to tell you a bit more about it. So there's another aspect to it. I told you earlier that the arbitration agreement could exist in the form of a separate agreement or form part of the contract itself. But you guys must have read in under contract law, there's a doctrine called doctrine of severability. So doctrine of severability, what it says, that if one part of the contract is illegal or void, avoidable, it could be severable. It could be separated from the rest of the contract. This the That's the same thing with section 16 and competence. Why would you say so? The principle of competence is the power of arbitral tribunal to decide on his own jurisdiction, right? It cannot stand without the idea of severability, because if there's infirmity or invalidity in the main agreement or main contract, you uh, since there's no response from you guys, so anyway, so the main agreement in which there's an arbitration agreement, right? If it is not allowed to be contaminated, the secondary agreement, that is the agreement to arbitrate, then the latter would fall upon the former. Hence, there would be no occasion for the tribunal to decide on its own jurisdiction. I hope I have made my point across. Anyway, so now section 16, the second section in chapter 4. Section 17 is interim measures by the arbitral tribunal, right? So I said that I'll deal with section 9 when I deal with section 17. So interim measures by the court under section 9, as I said before, that one party can take recourse to section 9 before the arbitral tribunal is constituted and after the award is made. But there are certain peculiar uh, facts and circumstances where one party could also approach the court under section 9 while during the pendency of arbitral proceedings, even though okay, Sumit K Singh is saying something. Sumit, I'll read your messages after I'm done with this. Is that fine?
Yes, sir. It's in response with the question that you asked you whether why is there the need of the Section 9 or the interim measures. So,
Okay. I'll read your response to everybody else if they cannot read it. But getting back to section 9 and section 17. So yes, uh, I lost the chain of thought. Yeah. So you can approach the court under section 9 before the constitution of arbitral tribunal or after the award is made. But there are certain peculiar circumstances where you could also approach the court during the pendency of arbitral proceedings, even though you have a recourse under section 17 to approach the arbitral tribunal itself for the interim measures. There's You guys should jot down the citation that I'm giving you. This case deals with this particular thing. The citation is 2017 SCC Online, Delhi 7226. This is Mahila Engine Components Private Limited case, right? So the peculiar circumstances are when the interim measures given by the arbitral tribunal are not efficacious enough, are of no use, then you can approach the court. If you can satisfy the court that the interim measures given by the tribunal are not efficacious, please grant me this relief, otherwise this arbitration would be of no use, right? So what are the interim measures, you may ask, right? So the interim measures are usually in the form of injunction to protect one's interest in that particular arbitral proceeding. So if there is a commercial contract and you require money, you have invoked arbitration, you are the claimant, and you require you're asking for your legitimate dues from the other party. The other party has could you mute yourself, please? Yeah, thank you. So the other party could alienate its properties or do away with its funds, so that you may not able, even though you get an award in your favor, you may not be able to enjoy the fruits of it. To stop this particular thing, we approach either courts or the tribunal to uh, grant interim measures, right? This, if I were to draw a parallel, this is in the form of the remedy that's provided under order 38 rule 5 of CPC and order 3912, that's injunction. You some of you may know about it. So interim measures under section 17. Now the arbitral tribunal is empowered under section 70 to grant interim measures, but what would be those interim measures that an arbitral tribunal could grant? That's securing the amount in dispute, right? Say for example there's 100 odd crores that you're seeking from somebody, and you suspect the other parties that they may not have it. So you could ask the arbitral tribunal that please have this money deposited in FDR, or if there's a property amounting to that uh, value, could be then a direction must be made that this property must not be alienated by the other party. The detention, prevention, inspection of any property. Yes. Interim injunctions, as I told you already, there could be an interim measure asking for appointment of a receiver also, or any other thing that you may justify that's in interest, that is in interest of justice. So, but there's one more thing, that you can only ask for interim measures against the other party, not any other third party, no matter how they are related to the arbitral proceedings. If claimant is asking for interim measures from the respondent, they can only ask from the respondent, not any third party. This has to be kept in mind, even though the third party might affect the realization of those reliefs. Now comes section 19. Section 19 provides for procedure of the arbitral proceedings, right? So right off the bat, section 19 says that CPC and Evidence Act are not applicable to the arbitral proceedings, and parties are free to decide upon the procedure. And if they do not decide upon their procedure, then the arbitral tribunal itself is empowered to choose the procedure that they wish to. Now you would ask me what the procedure is. So arbitration in effect is a civil suit. Okay, what usually happens is one party files, the claimant, the one who is claiming or invoking the arbitration. One party files statement of claim, the other party files statement of defense, and if in their statement of defense, or they along with the statement of defense, they could also file their statement of claim, right, saying that we have other claims against the claimant also, which arise out of this dispute itself, right? So, and then if they've introduced something new in their statement of defense, not just replied to what the claimant has agitated, but they've introduced new facts or elements, the claimant, the first party, could reply to those in the form of a rejoinder, right? Now all these things, and then there is evidence. If you guys are aware about how evidences are filed in courts, or if you're not, I'll just tell you, it's in the form of an affidavit where one party brings one witness who presents facts in support of their case. So it could be either from the claimant or the respondent, or both. That if I say that I need 100 crores from you, and I bring one witness that is related to those proceedings, and he says yes, this is why, and I say this on oath. So affidavits are always on oath, right? These are the procedural things. You could decide upon this, that the statement of claim would only speak to this. The statement of claim would be filed within this duration. The statement of defense would be filed within this duration. Rejoinder, if any, would be filed within this duration, so on and so forth, right? Usually parties don't, and this would also include the number of arbitrators, the duration of the arbitration itself, but that has to be less than what's provided under the contract, not beyond that, right? So the not contract, sorry, the Arbitration Act. So Arbitration Act provides under section 29A for a period of 1.5 years, as I told you earlier. 6 months for the pleading since the reference, and from 1 year since the completion of pleading, like 12 months the award has to be made. So in total 1.5 years, which is again extendable for another 6 months by the arbitral tribunal itself. And then if you need more time, you need to approach the court under the same section 29A. Anyway, so you are free to decide upon these things, okay, how the evidence would be taken, how the arbitral proceedings would be conducted, which usually does not happen, as I told you before when I was talking about the arbitration agreement section 7. Moving on, section 20, let's not talk about this place of arbitration because it's a settled issue. You guys should read about it, the place and the venue of the arbitration. There was earlier much dispute about it because it spoke directly to the jurisdiction of the courts, where you could approach the court for interim measures under section 9, or for section 11 for section 34, setting aside of the arbitral award, or section 36, that is enforcement of the arbitral award. For example, if I have in my agreement said that the place of the arbitration would be Delhi, then the courts in Delhi would have jurisdiction to entertain section 9, section 11, section 34, section 36, and for whatever relief you may be allowed to go to court under the Arbitration Act. Earlier it was of much importance, but the issue has been settled now. The place and venue are used interchangeably, and since COVID, it's much more clear. If the agreement provides for a place, then that it will, the jurisdiction of that place will the courts of that place will have jurisdiction to entertain these things, because now it's all online. Anybody from any place can be part of arbitral proceedings, or arbitral proceedings can take place anywhere. So that becomes a venue. If you guys need much more clarity to this, then you should read the Balco judgment. The Balco judgment is Bharat Aluminium Co Limited versus Kaisar Aluminium uh, Technical Services Inc. Okay, and if you need the citation, that is to 2012 9 SCC 552. Now, so this was part of chapter 5, right? Conduct of arbitral proceedings, section 19. There's another section 23, which is of importance because it comes up during uh, conduct of arbitration proceedings also. So it speaks about statement of claim and statement of defense. And this particular section, among other things, what is usually agitated in practice, provides for the duration in which a statement of claim and statement of defense are to be filed. That is, as I said before, 6 months. Now, let's come to section 29A. I think I've already told you about section 29A in am I Jaita, am I audible now? Is it better? Please let me know if it's better. Okay. Okay. So section 29A, I've already spoken about it, but again to give you an idea, because that is again as it agitated a lot in practice. What happens is, under section 23, you have to complete the pleadings within for 6 months, and then the award is to be made within 12 months of completion of pleadings. This is provided under section 23(4) and section 29A, right? Now what happens is, while filing section 29A, the relief is usually granted because both the parties agree in the interest of justice and interest of resolution of disputes. The court usually extends the time, but the computation of this time, sometimes that comes up as to when the pleadings were completed or what all constitutes pleadings. I would implore you guys to read upon it. There's a particular definition under section 2 that has a bearing upon it. When we get to question and answers, you guys should ask me about it, or should read about it as to why I'm posing this question, what pleadings could mean, right? Anyway, so that's about section 29A. Now, say for example, award is made, and now another, let's take a practical example. I was involved in a case where an award was made for about 334 odd crores. The award was made, the other party against whom the award was made approached the claimant saying that we could go to the court for setting aside of the award under section 34, or you could take lesser amount of money. Let's get into negotiations. Now, since the award is binding and enforceable in terms of the Arbitration Act. Why would any party choose it? For the simple reason that they don't want to prolong it anymore. So this is provided under Section 30. The arbitral tribunals are encouraged to uh, get the parties to settle. And this can also happen after the award is made and before it is enforced under Section 36. There's another interesting section, that's Section 33. So Section 33 provides for correction in arbitral awards, but it has a very limited scope. It only speaks to uh, typographical mistakes or any other form of mistake under in the arbitral award that does not change the effect of the award. Let me just give me a moment. I'll read the section. It's a small section. Correction and interpretation of the award and additional award within 30 days from the receipt. So it has the application for correction of the award, if any, has to be made within 30 days of the receipt of the award. Within 30 days from the receipt of the arbitral award, unless another period has of time has been agreed upon by the parties. Again, speaking to the party autonomy in arbitration, if both the parties agree for a longer period of time, that then they could also approach the arbitral tribunal beyond 30 days. A party with notice to the other party may request the arbitral tribunal to correct any computational errors, any clerical or typographical error, or any other error of similar nature occurring in the award. If so agreed by the parties, the party with notice to the other party may request the arbitral tribunal to give an interpretation to the specific point of or part of the award. So, two things. First, that making an application to the arbitral tribunal under Section 33(1)(a), you could ask them to correct computational errors, clerical or typographical errors. Why it is restricted to only these things? Because it does not affect the substantive effect of the award. It is only correcting the things, right? So for example, if an award has been granted to a party and then some sort of interest is also granted, say for example 8%, but the arbitral tribunal has not said 8% per annum, could you approach the arbitral tribunal to correct its mistake as to adding per annum after 8%? This is a question that I would want an answer from you guys after we are done with the session. Please keep in mind what I've explained to you about this section. It is of a bit of importance. And the second part, section 33(1)(b), that says that the parties could approach the tribunal to give interpretation to a specific point or part of the award. This is also, I think, in my personal opinion, this is provided because there could be complex issues that have been delved into by the arbitral tribunal, which are not as clear as they should be, or as they are not coming out as they should come out in the arbitral award. So they have asked for a clarification as to what do you mean when you say this or that, right? Or the second, which is which I think is a more in practice. So the arbitrators are usually judges, and they are in practice of writing complex sentences or making cosmetic change, or giving cosmetic makeovers to simple things and making them complicated. So these are the two reasons. The first one is there, like it's accepted, but the second one is my personal opinion, the cosmetic thing. Guys should not uh, take that as a universal truth or something, right? Now comes Section 34. Section 34 is Chapter 8. and it is titled Recourse Against Arbitral Awards. Now, since Arbitration Act is a complete code in itself and it provides for everything, and it seeks to minimize the intervention of the courts. I assume you all are law students and related to law in one way or the other. So you must be knowing that uh, the Arbitration Act seeks to minimize the intervention of the court as much as possible. Now comes section 34, and it says that if you're not happy with it, in simple language, if you're not happy with the award, you could approach the court seeking the setting aside of such an award. But on what ground? So, for a domestic award, or that's what we are dealing with, there are certain things that are provided under the section 34. I'd not read it in the whole because it's a very big section, but since there are certain important judgments, and speak about them. But just to refresh your memory, Section 34, application for setting aside arbitral award. Recourse to a court against an arbitral award may be made only by application for setting aside such award in accordance with subsection 2 and subsection 3. Now, what is subsection 2? An arbitral award may be set aside by the court only if A, the party making the application furnishes proof a party was under some incapacity, the arbitration agreement is not valid, the party making application was not given proper notice, the arbitral award deals with dispute not contemplated by or falling within the terms of submission to the arbitration, so on and so forth. There are many things, right? One of which is B2, which finds discussion in court the most. That is, the arbitral award is in conflict with public policy of India. Now they've explained it themselves. That was inserted in 2016. What is the explanation? For the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if, then there are three things: making the award was induced or affected by fraud or corruption, or was in violation of Section 75 or Section 81. It is in contravention with the fundamental policy of India. Now you see, it has become a bit complex because public fundamental policy of India comes under public policy of India, okay, or it is in conflict with the most basic notions of morality and justice. The other things that are provided under 2A, right, and there are five of them. They are pretty clear in what they prescribe as to when we can ask the court to set aside the award. But when we come to 2B, or specifically 2B2, the arbitral award is in conflict with public policy of India. And then it goes on to explain three things: that is, induced by or affected by fraud, it's in contravention of public policy or basic notions of morality and justice. The idea of minimizing the court's intervention is, in my opinion, is thrown out of uh, the sphere of discussion here, because there is no set definition of public policy, there is no set definition of fundamental policy. There are only guidelines that have been given by courts through judgments, through different judgments, and there are many, I tell you. Then comes the third one: it is in conflict with the most basic notions of morality and justice. What are the most basic notions of morality and justice? If you and I were, as students of law, were to make arguments for this, we could come up with many things that court may or may not agree with. So it has gone in the realm of abstract, but that's a point of a longer discussion. Let's not get into that. What I wanted to say is that the scope of intervention, even though it's limited, it's very narrow, but the scope for argument is pretty wide, and the court has to consider, and it affects the idea of arbitration, of speedy resolution of disputes, and it gives much scope for argument. That's my point. Anyway, so I'll give you, without getting into the judgments, I'll give you the judgments which you need to read for section 34. That is Renu Sagar, Power Co. and General Electric. The citation is AIR 1994, Supreme Court 860. Right? Then there is saw pipes. You guys must have, if you have not already, then you should read the judgment of Supreme Court in ONGC versus saw pipes, and the citation is 2003 5 SCC 705. Then there is another judgment, that's McDermott International versus Burn Standard Co. I don't think I have jotted down its citation, but it's fairly easily available if you guys find it on Google. There's another judgment of Supreme Court called ONGC versus Western Gecko, all dealing with public policy and patent illegality, right? So I want to say many more things about 34, but uh, if you guys read the judgments that I've given you in that order, in the order that I've given you, you'll have much clearer idea as to when can you approach the court and when can you agitate public policy for setting aside of the award, right? And along with that, patent illegality. Now, the last section that I'll speak of today is section 36. Section 36 is enforcement of the arbitral award. What happens is, even after getting award, and if there is no section 34 application for setting aside of the award, or even if uh, the party has not done so, has not made an application under section 34, then, and still not uh, giving you the money or following the award. If it's a declaratory award, then not following the declaration, or if it's a monetary award, then not releasing the money that you're entitled to, then you can approach the court under section 36 and ask the court to enforce it as that of a decree. According to section 36, an award is to be enforced in the same manner if it were a decree of the court. You guys are aware, I hope you're aware what a decree is. there's there's an argument which says that this is a legal, not an argument but an interpretation, that this is a legal fiction created by the legislature to make the process of enforcement of the awards smooth. And if you want to read a judgment on place of enforcement, even though that is not an kind of an issue anymore, usually it is in when you approach courts for enforcement of a normal decree that you've obtained through courts, not through arbitral tribunals. You could read Sundaram Finance Limited versus Abdul Samad and another. The citation is 2018 3 SCC 622. So that's about it. There are other things as well. There's section 39 also. there's section 38, it goes up till section 43, but those are not of much importance. I'll rest it here. And if you guys have any questions, if you guys think I've missed out on anything, please let me know. Hello.
Thank you so much, sir, for the wonderful session.
Thank you for having me.
And if any participants has a question, they can write in the chat box.
Uh, okay, so first of all, I'll read what Sumit said. The need for interim release is because an arbitral tribunal. Your preservation custody. You're right, Sumit. Finds element in law of torts. I'd not agree, but not agree in totality with what you've written in the last line, Sumit. But yes, largely what you say is correct. Uh, Ganesh says, "How can a party challenge an
So,
arbitration?" Yes.
sir, I will be read the questions. You can answer them.
Okay. Okay. All right.
Okay. So, question of the Ganesh Vajrapul is how can a party challenge an arbitral award before a court on the ground that the arbiter made an error of law?
Very good question, Ganesh. So this goes to the fundamental policy of India, what I was telling you about earlier. Under Section 34 2B2, you agitate this argument that the arbitrator has not applied the law properly. So what would be the law? Indian Contract Act is the substantive law which governs contract, right? And the other law which deals with the arbitration is the Arbitration Act in itself, right? So majorly, what you're saying is the non-application or misapplication of Contract Act while interpreting the contract. So you make an argument that this particular interpretation is not possible at all. Not to say that this is one of the possible interpretations, because courts under Section 34 do not sit in appeal. They do not have a wider ambit of getting into that this could have been, or this should have been, this would have been. No. If what arbitrator has said is one of the possible interpretations, one of the possible views of interpretation of the contract, then it's well and good. But if it's totally not possible, then you can take that argument that the arbitrator has made an error in law.
Thank you, sir. The question of the Kushi is, sir, what does it feel like doing domestic arbitration?
Uh, so this is personal. I like it. Uh, I think, in my opinion, arbitration is the future of commercial disputes. It will, if the Arbitration Act is amended to make certain changes and it is streamlined a bit more, then it would be the first uh, point of resolution of disputes, and it would help in speedy resolution of justice, which is need of the hour. So to answer your question, yes, I like it. It's good. If you have interest in it, you should get into it.
Thank you, sir. So the question of Jayita Marak is arbitration called domestic arbitration? And what is the difference between arbitration and equity?
Okay, so the Arbitration Act does not say domestic arbitration anywhere. It only says arbitration and international commercial arbitration, if at all. And the second question, is there a difference between arbitration and equity? I think you wanted to ask me something else, because both are different things. Arbitration is a mechanism of resolution of disputes, and equity speaks to be doing right by people, I think right by parties in equity, right? Then what ought to be should be. It's not related to arbitration. And just to extend on something which I think you are asking me is, arbitrators are not allowed to make an award on equity. They are only there. They are only allowed to operate within the bounds of the contract. They cannot go beyond the contract. They do not have the power as that of the courts to grant an award or grant relief on the basis of equity.
Thank you, sir. The question of Lakshman Singh is, what will be your key suggestion for those who want to become an arbitrator? What are the mistakes that young arbitrators make that should be avoided?
Lakshman, I have not been an arbitrator myself, so I'd not be able to ask the last question as to what mistakes the young arbitrators make. But if somebody wants to become an arbitrator, you should develop a niche, right? Say if you're doing it infrastructure arbitration, right? And so let me restart. So anybody can become an arbitrator. It's subject to the agreement of the parties, right? If somebody feels that you are the right person to resolve their disputes and you have the requisite qualification for it, qualification not in the manner of years, but your educational background or your ability to resolve the disputes because you have the know-how of the matter. Say for example infrastructure arbitration, you know how infrastructure works. If there is technical dispute, will you be able to get into it? It's not just about law, right? You have to know the law if you are a law student, but it's not just about the law. So if the arbitration goes into disputes of share purchase agreements, so you should have knowledge of company act, you should have knowledge of SEBI, you should know how um, M&A transactions are undertaken, these kind of things. So technical know-how or knowledge of the subject matter, that should be the primary thing that you should have. And then there is experience in our field. Experience is valued more than anything.
Thank you, sir. The next question by the Tamanna Pasi. In
Yeah.
domestic arbitration, as we have discussed earlier, also that instead of witnesses, records, and documents are preferred, and so there are chances that the decision making might wrong due to lack of evidence. What is your view in it? Also, what if the parties are not satisfied with the award?
I'll just read it. uh, no, we have discussed earlier, instead of witnesses, records and documents are preferred. So Tamanna, right? See, the realm of dispute resolution, be it before arbitration or the court, can only proceed on what you have placed before the court or the arbitral tribunals, right? So if somebody is in possession of a document, or if somebody can produce a witness to substantiate their case, well and good. But if somebody is alleging something and they are not backing it with some evidence, some corroborative evidence, then that would go against the basic notions of natural justice. That would go against the basic principles of evidence. That would go against the basic principles of pleadings. So you cannot go before an authority and make random statements and not back them up, right? So the chances that decision making might be wrong due to lack of evidence, that's upon the parties, that's not upon the arbitrator, right? I hope I have answered the first part of your question. And also, what if the parties are not satisfied with the award? So if parties are not satisfied with the award, you have recourse under section 34. If you can make the case that's given under section 34 to A or 34 to B, Well and good. Go and get a set aside.
Thank you, sir. Now, the next question by the Sumit K. Singh. Sir, suggest some books to follow up on the Arbitration and Conciliation Act.
Yeah, there are many, but before books, I would highly recommend that everybody read the Arbitration Act properly first. Secondly, if you have to read commentaries on it, then there are arbitration commentaries by Mullah. There are arbitration commentaries by one Mr. Dharendra Rautri. There, there are many actually. One there's one by a famous High Court justice that I'm not able to recall right now, but I'll I'll just send these recommendation to Legal Vidya Sakshi, and she can then forward it to you guys along with your certificates of participation. If I hope that helps.
Thank you so much, sir. Now, I will call Sakshi Sharma for the vote of thanks.
Thank you so much, Paris. Firstly, thank you so much for joining us today, sir. It was an honor having you, and you really explained the topic, domestic arbitration, to each and every participant very nicely, including me. This was the first time someone has explained this topic in such a great manner, and I'm pretty sure it will be stuck with me through the rest of my life. So, thank you so much for taking out your valuable time and joining us today, sir. It was an honor, and we really hope that we can connect with you in future as well.
Definitely, definitely. And thank you so much for having me today. And I hope everybody here all the very best. If you guys choose to come in the field of the arbitration, the most welcome. It's so much rewarding field if you be a little patient, right? And all the best. I enjoyed myself here, and if you guys have any suggestion as to how if I went wrong with something, or if I was going here and there, those are also welcome, so that if we meet next time, I could keep those things in mind.
We definitely will share the suggestions, sir. I'm pretty sure that everyone is very satisfied with this session and they'll give you great reviews. And I'll definitely be sharing the reviews with you as well.
Thank you so much.
Thank you, sir.
Okay, all the best to everybody.
Thank you so much, sir. Guys, you can all leave the session now. And if there is any question, do let us know. We have already shared the feedback forms with you. We'll be sharing it in your groups as well. Do give us a feedback and we'll be sharing the same with sir. Thank you so much for joining.
Guys, you can leave the session after the filling of feedback form.